When you misrepresent, it means that you knowingly, directly or indirectly, either withhold material facts or make alterations or somehow create fraudulent material to receive the decision that you are hoping to receive. So in other words, first of all, we need to focus on material fact. Those are the facts that affect the decision of an officer. The second thing is to not disclose information to the immigration officer or make changes to the information so the officer makes mistakes when they make a decision about your application. Of course, the important portion of the whole aspect of misrepresentation is that you knowingly do it. But whether you do it directly or indirectly, it doesn't matter. In other words, if you hire somebody to do misrepresent on your behalf and you know that, then you are still misrepresenting. Okay, so what are the consequences of misrepresenting? The first thing first is under Section 40 of the Immigration Act, when you misrepresent, you become inadmissible to Canada for a period of 60 months. What does that mean? This means that if you are inside Canada, then the immigration authorities will remove you from Canada. You receive something called an exclusion order, which does not allow you to come back to Canada for a period of 60 months. If you are outside Canada, then from the day that you receive a negative response from the immigration authorities, then you are inadmissible to Canada for a period of 60 months. Are there any solutions to misrepresentation? The first thing first is that when the immigration officer suspects that you are misrepresenting, they send you a letter called a procedural fairness letter. You receive that through an email or by mail, most of the time by email. When you receive that email, the officer usually allows you a period of time, like 30 days to 60 days, to respond to their concerns. This is your moment. This is your moment to convince that the misrepresentation has not happened knowingly. If you convince the immigration officer that either there is no misrepresentation in the first place, or if there is a misrepresentation that looks like misrepresentation, it is not being done knowingly by you, then in those cases, the officer may drop misrepresentation. They may still refuse your application, but at least you won't become inadmissible to Canada for a period of 60 days. But what if you try to fight back and convince the immigration officer and they are not convinced and still pursue misrepresentation? In that situation, you become inadmissible for a period of 60 months. If you want to immigrate to Canada within that 60 months, or if you want to travel or study or work in Canada, unfortunately, that's not an option because you have already been inadmissible to Canada. You have some alternative options. One of the alternative options is to hire a lawyer and file for something called judicial review with the Federal Court of Canada. The judicial review process will go through the federal court, and if the federal court finds out that the officer made a mistake in terms of making you inadmissible to Canada, then they will reopen your case and another immigration officer will review it to see if they actually can lift misrepresentation. So that's one of the options. The other option is called a TRP, or temporary resident permit. A temporary resident permit means that you want to go back to Canada, and going back to Canada justifies your inadmissibility to Canada. So you need to show strong reasons as to why you definitely need to go to Canada. And if they are convinced, then they will issue you a temporary resident permit and you will go to Canada despite being inadmissible to Canada. If you have been removed from Canada or you have received an exclusion order, then you need to apply for something called ARC, or authorization to return to Canada. Again, you need to show why you deserve to be able to go back to Canada despite being considered as a person who has committed misrepresentation. The other option, of course, could be application for permanent residency under humanitarian and compassionate considerations. To be honest with you, the chances that you succeed are close to none with HNC applications, but if you have convincing documents, then the immigration officer may consider your HNC merits and allow you to immigrate to Canada regardless of being somebody who is inadmissible because of misrepresentation. The last and the least is that if you have already been refused because of misrepresentation, but at that time you didn't have representation or you didn't know what to do and you received that, you could potentially hire a professional and ask them to negotiate with the immigration authorities. Obviously, that professional, the first thing that professional will do, submits a request, an ATIP request, and they receive information about your case as to why the immigration officer concluded that you have misrepresented, and then put together a package and try to convince the immigration authorities to reconsider their decision. The odds of winning a reconsideration battle are very low, extremely low. But in some cases, it's worth it to give it a try. Your best bet would be, in most cases, an application to return to Canada or an ARC if you have been removed from Canada. If you will refuse while you were outside Canada, a temporary resident permit application. In some cases, judicial review, and in very rare cases, request for reconsideration. You also need to know that if your application is refused because of misrepresentation, you have no right to appeal that decision to the Immigration Appeal Division. The only exception to this case is when you sponsor your spouse. That's the only exceptional situation. When you're sponsoring a spouse or a child, then that's when you can appeal the decision to Immigration Appeal Division.